Hi everyone, welcome to Glorious Learning Hub. Today I want to continue my presentation on infringement notice, your possible defenses and what the police has got to prove. Today I will talk about the more serious offenses like drink driving. So if you are charged with drink driving, that means that your blood alcohol concentration was over the allowed limit. The allowed limit is 0.05 and under. But it is 0 if you are a P-plater or a taxi driver. You don't have to have any atom of alcohol in your blood at all. So if you are charged with drink driving, the prosecution has to prove that you were driving and that your blood alcohol concentration was over the prescribed limit and that the sample was taken within 3 hours while you were driving and that you were the driver as well. So if they charge you with that drink driving, your defense might be that the device they used was not working properly or that they took the sample after 3 hours. So if you were found guilty, you might lose your license, especially if that was not the first time. It is not a defense to say that you were under the limit. Often the police will lay 2 charges, but you can plead guilty to one and ask them to withdraw the other one. So most times they charge you with providing a sample of blood or breath that exceeds the prescribed limit. Or they can charge you with driving or being in charge of a motor vehicle with a BAC over the prescribed limit. The police can use the outcome of the breath test as long as the procedure they used in taking the sample was normal. So to challenge this, you might say that the testing device was not working properly or was not used properly. So all drivers caught drink driving must have their license cancelled because the law changed and became more serious since April 2018. If you are caught drink driving, your license must be cancelled. Another offense is driving over the speed limit. You will be charged with driving over the speed limit if you were doing more than 25 kilometers an hour over the speed limit, or if you were doing 130 kilometers per hour. So the police has to prove that you were driving and you drove over the speed limit. Your defenses might be that you were driving to attend to an emergency or that you had a seizure. You could not control your speed because you had a seizure. It's not a defense to say that you were driving to work, that you were running late. It is not a defense to say that you didn't know that your speedometer was not working properly. It is not also a defense to say that you didn't know the speed limit because there was no signs around. So the penalty might be that you might lose your license for a period of time depending on the nature of the offense. You might get a penalty by way of fine. VIC may also add demerit points to your license, which takes effect from the date of the offense, not the date you went to court. So another offense is careless driving. Most times the police can charge you with careless driving. It doesn't matter that there was no accident. So most accidents are careless driving, except if someone hits you from the back. It doesn't matter if there was no one that was injured. Most accidents are careless driving. The prosecution has to prove that you were not driving carefully or that you were not driving with reasonable care in the circumstances. You will still be guilty of careless driving even if there was no accident. So your defense may be that you were not the driver or that you were driving with reasonable care. So if you are charged with careless driving, please seek legal advice before going to court. Another offense is drug driving. The police may charge you with drug driving if they think you have an illicit drug in your system while driving. So the police sometimes conduct random checks on the road to find people that are driving under the influence of drug or alcohol. So in terms of drug driving, the charge may come in different ways. It could be that you were driving with an illicit drug present in your oral fluid, which means you may have taken ice, ecstasy, or cannabis. It could be that you were driving with more drugs than prescribed in your system in terms of if you are having drugs or prescribed medication and you did not have it according to the prescribed dosage. Maybe you had overdose. You did not have it as prescribed by your medical practitioner or dentist or the pharmacist. You had overdose. You could be charged. It could be the reason why you were having more than the prescribed drug in your system. It could be driving under the influence. It could be refusal offenses. Refusal offenses is when the police stops you or wants to breathalyze you and you refuse, or to take your blood sample and you refuse. It is an offense to refuse or not to allow the police to take your blood sample or oral fluid. So the police can charge you with refusal. So in terms of your defenses, you don't have much defenses in this matter. You could say that in terms of driving while having more than the prescribed limit, you could say that you had the prescribed limit of drug or medication that you were prescribed with. That could be a defense. But most of the drug charges, you do not have a defense. So this is where I cap it off for infringement notice or infringement offenses. So watch out for my next video. In my next video, I will talk about another important matter. You can't afford to miss out on my next topic. Bye for now. Watch out for my next video.